Good evening, chat. Hello. How are you guys doing? Welcome to the show. It is a cold and snowy night out for us. It's actually kind of nice. Like, I hate it when it gets all snowy and it's like Sunday night because you're like, okay, well, maybe I'll fuck with the week. But it's Saturday night. It's getting cold and chilly out and like the snow's falling. And it's kind of a neat vibe. It's also neat when it's like a Friday night. But, anyways, here we are. Here we are. Tilly, how you doing, man? Hope you're doing well. And everybody worried about being late. You got suffer tonight, chat. Tonight, guys, we will be doing a little bit of working on stuff. We're gonna paint one of the things Stabby sent in, one of the Warhammer resins, because we have kind of as a neat thing I did for myself. We Black Friday that along with these micro mark paints. I went ahead and did the Vallejo. I got the color stack. So we're gonna do some like actual fucking like Warhammer painting tonight, chat. Where I'm gonna start smoking crack, plastic crack in front of you guys. So here we go. Do you have bread and milk? Yes. Oh yeah, guys. So Russell tried to claim I was posting information and YouTube. They actually responded pretty quick. The stream is back up now. I mean, like I'm almost halfway tempted to like just message him and like, if I just block out your emails, is that all you want? Because if that's the case, I mean, like there's nothing I can do about that. It's all public record. So, because some days he does it, some days it doesn't. I don't know. I don't know what happens there. Marlene says my son does Warhammer stuff. Yeah, I think it's pretty cool. I think it's pretty neat. There's a lot of neat Warhammer stuff out there. You tune in, I'm going to start smoking crack, yeah. Steve says we need eggs for French toast. We do have eggs. And we have milk. And, with French toast, we have bread. So I might, just between you and us guys, we'll probably call it early tonight. I'm probably going to make some French toast for 2.0 tomorrow morning. Do it my way with a little bit of cinnamon, a little bit of brown sugar, and the eggs, and a little bit of vanilla in there. Mix it all up. That's my plan. Justin Smith says, if you're reading this, you are gay. And yes, that is always important.
You are gay, LMAO.
Yes, LMAO, Lamau. Carla Vila says, I'm late. No, actually, I started at 7:40. So we made it. 4M, how you doing? Milk truck driver. Oh, like, how are you doing? Do you beep beep when you arrive? Okay. So, guys, this is going to get into all the things going on with Tyler Robinson. Remember, he is the man accused of murdering Charlie Kirk out at Utah Valley University. And back in October, there was a closed session to hear evidence and arguments about, him to appear in clothes and be unshackled previously. Today, though, it's going to be all about kind of transparency and different things that are happening today. So we're going to address that. We're going to watch this. It goes on and meanders for a while. Like there's some breaks. And then there's some breaks and stuff to do. So it's not going to be super long. Don't panic about that. You just pictured me chasing Bonbon around the house and running out. Well, I'm not going to chase after her. I'm going to walk after her. Like, come on now. He should be, Shredder S says he should show up in the furry costumes he wears. That would be hilarious. That would be interesting. Corsicade says, we've been getting lake effect for days here. Yeah, I think it's really going to pick up tonight for us. So we will be doing that. Clyde and Bonbon are working together on a project. I can see them. I don't know what they're doing. I'm going to put mayo on my front toast de Francois. Yes. But Candace told me it was the juice. Yeah. Well, Candace seems to think there's all kinds of things. Like, and that's the thing, guys. This guy killed him. There isn't some sort of elaborate conspiracy. I know there's all this nonsense now about like, well, it wasn't a 30. We've been through all that. He used a 30-06. He shot Charlie Kirk. Charlie Kirk died. That's all there is to it. That's all there is to it. Shredder says, "What's the goal?" I mean, the goal is to have a good time. That's the goal. At least I'm not going to trying to be a surgeon tonight. Yeah, I saw that with that guy had JFG on, and I'm like, I really wanted to message that dude and be like, bruh, he ain't the medical person you want to have on. So, oh yeah, I'm in on it exactly. So let me see here. It's omelet night at your house. Wow. Bella says, "How long have I been on?" Like 5 minutes. Oh, hey, Clyde, come here. Clyde, hey, there you go. He's like, how? Was that you or her? Because I grabbed you. You slipped a little, buddy. It's okay. It's okay. I got you. I got you. It was Master. Yes, it was Shredder. They used the Technodrome. They had the Technodrome to go after. Lama Krang. So. Yes, I heard about the lawyer that got body slammed by the victim's family member. Yeah, but it turns out that guy has like a history of like violating protection orders. So don't give that guy credit. He's doing some base thing. He sounds like a guy who beats women for fun. And the lawyer protected his client. So, you know, good on the lawyer for riding for the brand all the way. I mean, that's pretty epic. Bon, well, you asked to get picked up and then you don't do anything. Dingleberry. All right. Well, Clyde, how you feeling? You know, Clyde, what's your goal tonight, Clyde? Do you have one? No. You have to look at them and tell them. Buddy, up here. Look, Clyde. Look at the camera. Look at the camera. There you go. Show them you have eyes. Yeah. Bon. Yes. All right, chat. I claim I'm not body slammable. No, if the mountain, if Julius Hafthor Bjornsson, I'm sorry, Hafthor Julius Bjornsson comes and body slams me, I bet he could do it. I bet Martins Lisi's could do it. I bet all the guys on the World's Strongest Tour. Shredder S07 for $5 says funds for a good time. And then Mega Mobas says make your friend toast for a woman. Yes. The things we do for the people we love. On a scale of steel toe to Nick, how gay are you? Also, fuck Greer. Well, that's like saying on a scale from 1 to 0. So that's not very accurate or helpful. But yes, I cook for 2.0. Don't make her do it all on her own. Huh, buddy? What do you want something, huh? What's wrong? You know, like, I feel like you're just using me because you're like, the fat man is like safety. That's what I am. He doesn't want me. He's like, I don't love you, fat man. You just keep me away from Bun. Because he's looking down the hallway towards where 2.0 is. He's like, that is where I wish to go. Do you want to go there, Clyde? Do you want to go see 2.0? Come on, Bubba. Come on, Bubba Bear. Okay, I'm going to set you down. Here, we'll squish Bon. Bon, hey. Bon. Clyde, get out of the way and let me get Bon. Hey, buddy, it's okay. You're all right. That's okay. Bon, hey. Whatever. They're screwing around. Let's get to the Tyler Robinson trial. Pre-trial hearing. So, also, if you're a Big Ten coach and you're having an affair with a staffer, be sure to turn her in before she turns you in. Yes, and then don't show up at her house with a knife. That is never a good idea. You're going to call Brian Shaw to do it? That guy could do it. He could also do it. Grassroots Hegemon for $20 says, have you considered snuggling Clyde harder? I do routinely. I snuggle him pretty good. But thank you for $20. 20. Will I be covering the legal issues of a certain blood magic pirate LARPing in Vermont? Yes, when we get a little more on that. I know Styx did a whole discussion about it. And then there was I guess something happened out in Rhode Island. Some guy started playing Duck Hunt at Brown, which is like, that's kind of interesting. I don't know anything about that yet. If there's any other it sounds like it may, because it's in Providence, and Providence isn't they made it sound like there were like 20 people dead or shot or something. But it's the final exams, but it's Saturday. I don't like, people are saying all kinds of stuff. So we don't really know. But 2 people died, which, rip to those. And that'll be kind of it for now. Cash tells us the FBI's on the scene. Yeah. 2 dead, 8 wounded. Okay. Final start today, Sean. You had Saturday class in college? Really? Oh, I never did. Never did that. Let's see. Duck Hunt was awesome. Yeah, but in high school, they don't think that's a very appropriate way to describe like a school shooting. Some guy coming to play Duck Hunt during study hall. I got in trouble for that. Because we were talking about school safety, and they're like, well, if something happens, if dynamic events happen, and the girl's like, what does that mean? And I'm like, that means somebody's coming to play Duck Hunt during study hall. And they thought that was very inappropriate. It was very inappropriate. Is Coulter's law in effect for the shooter? Well, it sounds like he escaped, but it could easily be on the edge of Providence, Rhode Island's kind of like, so might even be school related. Yeah, they call it a dynamic event. Oh, yeah. So anyways, let's get started. Tyler Robinson, he is going to appear here in court. Gets up and giggles at the gunman when he misses. Yeah, I'm like the dog. You had bowling. Okay, yeah, but there's some classes. Okay. Yeah, but I meant like real classes. So anyways, here we go, guys. Tyler Robinson. And, we're trying to, all the different theories that are out there of what he is and what he does. I'm not sure. Oh, Stabby, we are going to do you're here, that big resin guy. The one you sent me, the guy's got the sword. I forget who you said he was. We got to reglue the sword, though, because the sword had a crack on it. So we got to work. We'll work on that guy tonight, so I hope you're sticking around. But anyways, let's get to Tyler Robinson here. So here we go, chat. This is disappointing. There's no closed captioning here. I'm going to try to find a better one. The one I found earlier wasn't the best, but I want to find one that's got closed captioning. I think that'll make it a lot more fun for us and a little more tolerable, because otherwise, it sucks and we can't follow along. We can't follow along there. I think this is it actually here. Never mind. Found the good one, chat. Found the good one. I had it before and I couldn't find it. Long crime trials. Here we go. We'll do a little bit of movie magic here. 1.25%. Here we go, guys. Anyways, so that's Tyler Robinson. Looking okay so far.
Database of the people's systems, right? It's not an interview. If you want, I'll identify okay.
Also, I'm not going to buy all the nonsense of like all the lip reading and stuff. I don't know if any of that's accurate anyway, but it's just something to be considered about. Like when you're doing these types of cases, every conversation has to be protected, because he might be talking to his lawyer right now. But if you're doing it, people can hear it. It's no longer privileged. So you got to be careful. Got to be careful.
I thought this was work.
Just a database entity for people to say.
I'll identify what it's
Just a database of for people to say. Right? It's not an interview.
If you want, I'll identify what it's
I know. I've seen that before.
All right, we're gonna skip ahead here a little bit. Now, this whole thing where people are like, "Oh my god, he's he's not just gonna go the whole time." Like, people have moments of levity, and if your attorney smiles, you're gonna smile. Like, part of their job is like, they're not gonna sit there like monks either. So, just something to think about. Something to think about. This is so dangerous, and I think that the next time around, they're going to be telling him, like, look, when you speak, like, hold up your notepad and we'll talk behind it, because this is not safe. This is very dangerous for the defense.
Please be seated. Court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt.
Closed captioning wasn't transcribing all of him. It was transcribing other people in the background talking. And this is AI transcription, so it's not going to be reliable enough anyway.
On behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser, on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff
Please be
Hunt
seated.
and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Court is now in session.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of.
Is this
media
sounding
interveners
over
also
itself?
identified in the brief.
Oh my God, did it sound like it's like playing over itself?
Good afternoon. Counsel, if you could enter your appearances, Mr. Robinson, in the courtroom as.
Am I hearing that over itself? What the fuck? Hold on. That was weird. God damn it, Long
Good
Cry.
afternoon, Your Honor. Jeff
Please be
Hunt
seated.
and David Ryman appearing on behalf of the media
Yeah, Long Cry screwed
interveners
this
that are
up.
identified in our motion papers.
Court is now in session. 7-6. Good afternoon. State of Utah
Good
versus
afternoon, Your
Tyler
Honor.
James
Kathy
Robinson.
Nestor, excuse me, Richard Novak.
Counsel, as
Stacy
we're moving
Visser,
forward
on
today,
behalf
I
of
want to
Mr.
give
Robinson.
an overview of what we anticipate doing.
Good afternoon, Your Honor.
And
Jeff Hunt
it
and
comes
David
down, we're
Ryman
addressing
appearing
three
on behalf
issues.
of the media.
The first
interveners that
is
are
the
identified in
October
our motion
14th,
papers.
2025 audio recording
Michael Judd,
of the
Your Honor,
closed
Parsons,
hearing
Bailey, and
and
Latimer,
the October
on behalf of
24th,
another set of media
2025
interveners
transcript
also
of that
identified
hearing.
in the brief.
The second is the state's motion to amend Mr. Robinson clarify the publicity order. For the benefit of the record, calling case 251. Finally, 403, the motion for limited intervention, a request for notice Utah versus Tyler James Robinson. Seal or reclassify. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues.
Guys, I don't know why there's the two audio tracks, but there's multiple issues that are getting addressed here. I think it got fixed.
We will invite all parties or the public and the media to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the, and the hearing will not be broadcast.
So there's going to be a second, there's a part of the hearing that's not broadcasted, which is bullshit, and that should be broadcasted so we can hear it.
excuse me, Richard Novak.
Council, as
Stacey
we're moving
Visser,
forward
on
today,
behalf
I
of
want to
Mr.
give an
Robinson.
overview of what we anticipate doing.
Good afternoon, Your Honor.
And
Jeff Hunt.
it comes
David
down, we're
Ryman
addressing
appearing
three
on behalf
issues.
of the media
The first
interveners that
is
are
the
identified in
October
our motion
14th,
papers.
2025 audio recording
Michael
of
Judd,
the
Your Honor,
closed
Parsons,
hearing,
Bailey, and
and the
Latimer,
October
on behalf of
24th,
another set of media
2025
interveners,
transcript
also
of that
identified in
hearing.
the briefs.
The second is the state's motion to amend Mr. Robinson clarify them as listed afternoon. Commonly for the benefit of the record, calling case 251. Finally, 403, the motion for limited intervention, the request for notice Utah versus Tyler James Robinson, seal or reclassify. Council, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. So as we begin, the first is the October 14th, 2025 audio recording, the October closed hearing, and the October 24th.
This is schizophrenia, feels like, I guess.
So that I may hear from the parties regarding
Hold on,
state's motion
Chad.
to amend the public. Finally, I need to hear if it's affected, and it would will resume parties or the public and the media to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention.
This is nonsense. This should all be available. This should not be restricted like this. I don't think this is legal, but who knows?
Followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother, and we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it. I believe it is appropriate to treat all parties in the public equally, though I do recognize their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you.
Yeah, this absolute closed session is garbage. They shouldn't be able to do this. Yeah, every trial should be open and recorded to the public. Yeah, I think juvenile, like for children, is the only time it shouldn't be. For like kids, like if juvenile delinquencies. But yeah, this should be all available to us. This should not be stuff we can't experience. So we're gonna time travel here, chat. We're gonna time travel. I mean, like, look, guys, we're 11 minutes in, and like, woo! Look at this! Look at this! Look at this! Look at that! We are just time traveling mofos. So here we go. Here we go. Look how fast we can go. So look how fast we can handle this. Look how fast we can go. And we are going to move on to the next part of this. Here we go. But Tyler's lawyer is saying his family will abide. Would that make him their lawyer too, as he speak on their behalf? No, he's not, but they're just arguing he's family, like that they'll abide by the court order, because anything said in there probably isn't helpful to Tyler. So they won't intentionally fuck his case over, is kind of what the argument they're trying to make there. At least is what I could figure. So that's kind of what they're getting at. You're muted, Judge.
We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before. And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that this specific circumstance is warranted. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear. And if there's been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation. But we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
Your Honor, Jeff Hunt for the media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers. But filming of the inadvertent filming of the shackles, I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper. That was inadvertent. And we apologize for that. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation. Filming of the computers is not a violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail.
Yeah, but it shouldn't be an issue of what are they looking at, and then we have to go back through and see what they see, because there could be work product. There could be all kinds of shit. So the prosecutor here is kind of pish-poshing his way around. That's a little bit ridiculous.
Detail the shot is that is of concern to the court. But I'll just say that we reiterated.
Yes, 100%. Showing that person in shackles presumes he's guilty. It's the same reason why a jury is not allowed to see you in shackles. It's the same reason why a jury is not allowed to see you in a jumpsuit and you have to be dressed in civilian clothes for trial. We don't want to do that to you. It's unfair. I'm sorry. Yeah, the media lawyer. I'm sorry. Yes, he's the media lawyer. But yes, we have the right to not be prejudiced unfairly by the jury. Remember, Tyler Robinson has a right to a fair trial. Yes, guys, I said lawyer for the media. Yes, I misspoke. So, but yes, this bullshit with it. Scorpio said saying he didn't do it taints the jury pool. Remember, only one side's entitled to a fair trial. Tyler Robinson has the right to a tainted and slanted and biased jury in his favor. The state's just not allowed to that. So that's the difference here. That's the difference here.
As soon as I heard this from Mr. Ballard with the pool representatives, that this is very important to follow to the letter of the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter the court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives. And we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restart it. So it's still a problem.
Thank you. I appreciate all parties weighing in on this important matter.
Interesting. They're getting like real-time text and everything. I will say that's good that they're planning that to make sure, like, hey, we need to double check this stuff.
I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the EMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings. And again, if there are specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the session, and cannot be filmed before or after. The filming of, as previously stated in the decorum order, EMC must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this to take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best.
All right, chat. So, yeah, we got to fix it. It still has to be fixed. So they got to move everything around. And notice now we're going to be on the other side of the room. Here we go. Now we're on the other side. So his shackles can't be seen. And then they can't hear him talk, which I think, yes. I'm just surprised in a trial like this, that wasn't pre-designated and discussed. That they didn't already anticipate this. I'm a little surprised at that, but hey, what do I know? Drunken Gold says, is he a danger? Why is he shackled? He's going to be shackled at the ankles because of jail policy. They have very special rules to do things as far as, in trial, you won't be shackled, or maybe you are shackled. Maybe you're a security risk still. I'm sure he's considered a high security risk, because he's a murder suspect. So that's the main reason why he's going to be shackled like that, if I had to guess. Have they taken judicial notice that he was dating a tranny? I don't know. It's superior defenses. We got a bunch of snow in Columbus. I was shoveling all day. I heard about that. You guys were getting smoked down there. Yes, very serious. So... you assume he can be shackled anytime he's outside the presence of a jury. Yes, that's a common thing. Or if he's getting moved around to the courthouse, he'll be shackled up. But all those are going to be very special, coordinated movements.
And of course, I'm looking for my notes, and they've disappeared, but that's okay. It happens. All right. Let's go ahead and address the state's motion to amend or clarify the publicity order. and I'll hear from all parties. And I know it has been briefed, and responses, but I'll hear brief argument, and then we can go from there. Mr. Ballard.
Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that term just be limited to the prosecution team because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor. So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the prosecution team because if that term stretches beyond.
Well, remember, guys, that when we talked about the gag order, it was like the prosecution, all law enforcement, and potential witnesses. Well, it's like, how does he know who's a witness or not? And he doesn't have control over a witness necessarily. Like, there's only generally only the parties should be held by a gag order. So there's nothing wrong with him doing this. I know you guys are upset, but I'm like, yeah, makes sense to me. Makes sense to me to do this.
Just the prosecution team, then the order is written, we don't believe is a valid and lawful order because it would result in a prior restraint on certain speech and at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order. And to
guys,
make sure
this is from the prosecutor's office. Because you hear him talk about Rule 3.8. That's the special rule for prosecutors. They have their own rule in the rules of ethics. They're bound by that's different. Okay? So something to think about. Remember, this is the state saying, look, you can give us some rules, but like some of this shit's a little ridiculous.
that they do not make a statement that the prosecutors themselves would not be able to make, a public statement. But if the order extends beyond that, then we have concerns because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint. As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint,
it's going to be very tough
to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures, and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And as the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue.
And see, chat, this is how the law works. Hey, that just happened. And notice they're using the Aaron Spencer case as a blueprint to justify, look, judge, please narrowly tailor it because we have to be able to comply. We can comply with the order in the Spencer case. So it's very funny. Like I said, guys, it's neat when these cases all refer to each other because we've already talked about those.
In explaining the analysis that applies to various different people that might be associated with the criminal case. You have attorneys, that category of trial participants. Certainly the court has the highest degree of ability to be able to restrain the speech of attorneys. And in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are several people associated with this case who have very significant interests in exercising their First Amendment rights in talking about how this case has affected them. And of course, can't say that one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger or a greater interest in speaking than others. And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation for the state to be able to comply with that order, depending on how the court clarifies what witnesses mean. Does the court have any questions for the state?
No, thank you,
Okay, thank
Mr.
you.
Ballard. Mr. Novak.
Thank you, Your Honor. I'm going to try to be brief because our views on the propriety of the court's order were set forth in a publicly filed document, which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public. And it's certainly not, I think, as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we...
The 51, I have the closed captioning on because there are people who have trouble hearing. I do that as like a courtesy to them. I can lower it down a little bit more. But like I leave it on so they can see what's going on because not everybody can hear well, but also people are in situations where they necessarily can't have their sound up. So that's why I know there's people who have trouble with that. So that's why I do that.
Noted in our papers is direct.
Also, I do like the fact that the defense is like 100%. They're like, yes, judge, have this overly broad and extremely vague gag order in place so we can beat the prosecutor's office up with it. And the defense is like, keep doing it, judge. We love it.
At the conduct of and the court's expectations for counsel. So even if under that order that the court issued, somebody who we could all agree is a witness within the court's definition of that, made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may in the future be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term. So it is our view that the court's order is not overbroad. It's not vague. It doesn't put
I think it is, though.
the state or the state's attorneys in some untenable position. And I think it's a little too simple to say witnesses are either everybody under the sun or people who are under subpoena at the last second, because counsel have not only the training, but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue, and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party. That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers, we refer to it as a potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants. And we don't believe that that creates an enforcement problem. We don't think it creates a compliance problem. We noted in our papers, and I'll emphasize here again, that the court's order actually places responsibilities on defense counsel that the rules don't. The rules have special guidelines for the prosecution, and the court has expanded that to include the defense, and we don't have a problem with that. I also think that the standard that the state is suggesting for when a potential lay witness, as we've defined that in our papers, may make public statements that violate the court's order, the best standard is actually the one that we believe the court should look to, which is the standard set by the 10th Circuit, because as the state points out, it may be that there isn't any Utah law on this issue. So it seems to me that the closest source of authority on this constitutional question is going to be the 10th Circuit, and that's the case United States versus Tijerina, and I'll spell it. It's Tijerina, 412 Fed Second 661, 10th Circuit 1969, where the court says that the constitutional balance between the First Amendment rights of a non-attorney participant and the defendant's right to a fair trial are properly balanced where extrajudicial statements present a reasonable likelihood of prejudicing a fair trial. That is a more protective standard than that which appears in Rule 3.6, and we think it's the appropriate standard which should be applied here. That's part of, as we've told the court before, a motion that we will bring, because we actually think that while the court's order is wholly appropriate, it's not vague, it's not overbroad, it's not a prior restraint, it doesn't create a lack of clarity for the state. We would like it to be a little bit broader in other areas, especially concerning the standard to be applied and the definition of what is the prosecution team, but that's not germane to here. So we think that while we understand the state's concern, we think that their motion should be denied. I think at the last hearing, the court actually clarified verbally from the bench what it meant by a witness, and I think that's pretty close to what we described in our papers as a potential lay witness. So I feel like if I say anything more, I'm going to be reiterating again what's already in our papers. If I've muddled it, I'm sure the court will tell me and I'll clarify it. I hope I haven't.
Thank you, Mr. Novak.
Okay, thank you.
All right, and we'll turn to the last matter. Anything further, counsel?
Yes, thank you, Your Honor. I do want to point out that the court's order as it's written does impose limitations on speech. And the issue here is whose speech? Is it just the prosecution team members, or does it extend beyond that? And limitations on speech are a prior restraint. The court's order says that, if you look at page 2 of the order, it specifically talks about lawyers, that lawyers cannot make a statement that would violate Rule 3.6 and need to inform witnesses that they cannot make similar statements, and then requires the parties to inform lawyers, excuse me, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read, about the prohibitions contained in this
Very
order.
good question. We'll get
So
to that.
the order is prohibiting speech. And because if it extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do.
Thank you, Mr. Ballard.
Thank you.
All right. Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify. And I'll hear from the parties on that.
Thank you, Your Honor. David Ryman, representing the news media. Mr. Judd and I represent different groups of clients, so I'm going to invite him if I miss anything to weigh in after I'm done. But my intent, the issues are basically the same, so my intent is to address them for all of the interveners at once, and I'll be very brief. We have only ever sought, in this case, limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing. That is settled law in Utah. And the last filing at least, that we got from Mr. Robinson's team that just came in, I don't know if it was a couple days ago, basically gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the civil procedure rules in a criminal case, they said we don't need to do that. The woman in that case just needed limited party status. And so in a way, we're not really, the state really hasn't disagreed with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers that we've cited the court to extensive authority saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is for Mr. Robinson's team that we're supposed to do from here on out, but it kind of sounds like just this sort of ad hoc show up anytime you happen to see something on the public docket that might affect the public's rights. And that's just not the orderly way that this typically happens. The other thing, as I've mentioned in our papers, that it does is it allows for the media to be able to take an appeal of a closure issue without having to rely on the court's extraordinary writ jurisdiction. And that was what they had to do in either Kearns Tribune or Bullock, where the media was not granted party status. And it is the situation that happened in FL, where they had to review her claim regarding records under extraordinary writ jurisdiction rather than invoking their appellate jurisdiction because she was improperly denied limited party status. So all of that authority supports the process that we are requesting in this case. We think it's the most orderly way to do it. And I'll end just by saying, there's been some discussion, and especially from Mr. Robinson's attorneys, about what rule it is that you need to do this under, whether Rule 24 applies. They seem to suggest that it doesn't. I will just point the court to two different rules that give you the authority to do what we're requesting aside from Rule 24. Rule 24 is in the civil procedure rules, but Rule 81, and particularly subsection F of that rule, says that the rules of civil procedure govern in criminal proceedings where they don't conflict with.
And guys, this is an issue here where you have criminal rules, they don't fill all the gaps. And when there's gaps, the civil rules fill the gaps. Because generally, if the criminal rules don't cover it, the civil rules will cover it. And then if the civil rules don't cover it, you generally have like rules of superintendents that cover everything else. You guys are saying you would do jury nullification. No, don't do it. Spuggut says, do we think he's guilty? I'm pretty sure he's guilty. I mean, it sounds like he admitted to his parents, and it sounds like he admitted to the police. Yeah. Who is this guy again? He's the guy that shot Charlie Kirk. So, yeah, and this guy represents the CBS affiliate and all the news, and that's who is doing a lot of the feed work as a local affiliate here. So, and really quick, yeah, we'll get to these other things here in a second.
with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases have relied on that rule. The other one is Rule 31, and that's in the criminal procedure rules. And that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure. It's not civil procedure, but rather just procedural matters. And so that is essentially what happened in the FL case, which is that, whether you do it under Rule 24, whether you do it as a judicially created, remedy, it doesn't matter. It's the same, it gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing, we didn't take a position on the gag order motion that you just heard. We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure. Because as you know, and this is sort of why we're here today, a lot of time this just happens by stipulation, because these, the state and Mr. Robinson's lawyers, they may not want to fight over a particular issue. And so it really is a situation where no one really represents that interest. And the purpose of this whole process is to give the court the benefit of the briefing that we've submitted and the benefit of arguments to represent the public's right to attend these proceedings. So unless the court has any questions, that's all I have.
Thank you.
Thank you.
To the state, Mr. Beller.
Your Honor, as the state briefed in briefing on a prior motion, I think it's clear that parties have outside entities have the ability to intervene in a case as a limited purpose party when there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding. And there's well-established case law that allows the media to intervene, to be able to appear and be heard on matters of public access to court proceedings and to court documents. And Rule 4-202.04 of the Rules of Judicial Administration also make it clear that the media can appear and do just exactly what they've done in the closed session that we held earlier. So it doesn't make them a capital P party to the case. It makes them a limited purpose party, and they certainly have the right to be able to do that. Thank you.
Thank you, Mr. Beller. Ms. Visser.
Thank you, Your Honor. So I just want to clarify the issue really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case. And I think another part of that is what that means. And really that is what we are primarily concerned with. What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's what we learned from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal. So we're a little bit in the dark, and we're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.04, and their role is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want timeframes. We want orders saying this is when you need to respond, so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time. And we're not unreasonable folks. If they reach out to us, we will grant reasonable requests for extension, just so everyone is aware. But there was no communication. So I want it very, very clear what they can and can't do. It's less about semantics. This isn't about semantics. It's about substance. What are they allowed to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do. And I also have some practical concerns that maybe need to be addressed with the court's clerk. For example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So I think it would be appropriate if they are going to be added to the docket that it be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive something that they shouldn't have, they notify us in the court immediately and they delete it, they don't review it. At a minimum, I think that's necessary. But I also think it would be reasonable for this court just not to put them on the docket for that very same reason. So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know. But we do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers. Neutral observers. We don't want the chaos that is out in the media in this courtroom. So whatever this court can do to prevent that is what we're asking. Does the court have any questions for me?
No, thank you.
Thank you.
All right, counsel.
I don't blame them for going as hard as they can on this, but they're not going to get what they want out of this here. Do attorneys get paid by the word? No, but guys, this is the thing though. When you're up there talking, you're just like, especially when you're on the defense, because you're generally screwed on what's happening. You just keep talking and it's hard not to stop, and you go and you go and you go, and you're making sure, did I hit all the points? And Tech Guy South, you make fun of repeating. This happens all the time. Like, you're just like, and you're just like, you're making sure you covered everything. It's a very real problem. So, yeah. So, yeah, it is a real thing there. It's a thing. Zero Fucks saying, is the maroon shirt Jewish Mormon beekeeper that took an Egyptian plane from Israel? Yes. Yes. And Pepsi Man says, oh, this nib is going to jail forever. Yeah, he probably is. Megan Mobas says, oh, fuck the eye patch congressman, since YouTube won't let me name him specifically, respectfully. Yes, Dan Crenshaw is now demanding that Sean Ryan let him on his show or he'll sue him. So all kinds of gay Navy SEAL drama out there now. Radcon Hazard said there's already several videos that claim they've used a lip reader to determine what was going on. Yeah, I heard that. It's like, I don't trust any of that shit. So we'll see, though. We'll see. T-Rex Travels brings up, who really knew that Charlie Kirk was holding it all together? Yeah, really. It is interesting in that regard. So let's see here. Let's keep going, though, chat, in the meantime. Let's keep going. So attorneys are good streamers since they never shut up? Yes, they would be. So let's keep going.
Thank you, Your Honor. Just very briefly, I'm not sure what neutral observer is supposed to mean. We have interests in the case. We are here to advocate for openness and against closure. And so I don't think that's what counsel meant to imply, but that's the whole reason we're here, is that no one else represents our interests. That is straight down the middle of what the intervention rule requires. Just a couple of clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including judges in this building. Counsel said that our role is strictly limited to advocating for what is under Rule 4202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings. It just applies to records. So just to be clear, but I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for, which is just if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify. They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice. And then we have the right to be heard on those issues. And so I didn't really hear from counsel any reason why we should not be granted limited party status in this case, other than just some sort of, confusion on their part as to what that would actually look like. I don't know how the clerk deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point on, well, two things. One is that counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to your honor with an order, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, Mr. Hunt and Mr. Judd and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, if they don't concern closure, sometimes we don't weigh in at all. But, when they file things that they say we need to file this under seal and we're not allowed to see it, then the briefing for you is not super helpful, And so typically the way this happens is we are allowed attorney's eyes only access to, documents just like the state and the defendants would be. Their counsel can see things that are non-public, and we don't share them with our clients unless the court orders otherwise. And typically, if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are non-public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if there's a procedure where we can see them so that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. So that's just typically the way this works. So thank you.
Anything further?
Your Honor, I'm not going to belabor what's already in the briefing. I do think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context for what occurred in those cases. I can't argue against what happened in other cases. This is our case. Our case is different. This court has already acknowledged it. There are many interests. We have concerns about leaks, information getting out that shouldn't be out. I think those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court.
But you totally are impugning their integrity.
But the more this court controls the information that ultimately it determines to be private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and who did it. So we are objecting to providing the media our pleadings in advance, even just to their counsel. We don't think that's appropriate. I don't see any authority for that. We're asking the court not to consider that. And we're concerned about opening the door to multiple other entities, just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either. So our position is and remains that they can file what this court has authorized to file in the manner this court authorizes to file it and be heard in the manner this court indicates. We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So they should be able to file those things, but we do not agree that that requires status in our case. So does the court have any questions?
No, thank you.
Thank you.
All right. I appreciate the argument from all parties throughout this day. I wish to commend the preparation and the quality of the arguments, as well as the civility that is sometimes overlooked, but I wish to recognize that and appreciate counsel's demeanor and their arguments today. I previously stated when we began that I would be issuing rulings on the first issue. And when I began, I initially said October 14th. It's actually the October 24th audio recording of the closed hearing, as well as the October 24th transcript of that hearing. And so I wanted to make that small correction. But given the in-depth and necessary arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue. And so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close, seal, or reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. And so I will be issuing the ruling in regards to the state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on WebEx that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine it will take longer than 20 minutes for this court to issue ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on WebEx. And so I'll open it up to the parties.
We don't have any objection to that, Your Honor.
Thank you.
We have no objection to that, Your Honor.
Yeah, same.
All right. Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available.
Yeah, that is hard.
To our staff, what dates do we have available for a 30-minute block before the end of the year?
Judge, we do have December 29th at 10 o'clock.
Jeez.
How does that appear? How does that date work for counsel?
That was 10 a.m. on the 29th?
Yes.
Your Honor, that works for Mr. Robinson. Thank you.
Same for us.
All right. And to defense, in regards to Mr. Robinson, what is your position on, if it is on WebEx, he would be appearing by WebEx, or is there different thoughts?
Yes, sir. Have you heard of the sector of the Dabbleverse showing up to your WebEx or your Zoom? But guys, no, that the video stuff COVID has changed courtrooms forever. And it's good because we can have these short hearings like this that they're going to need to do.
Your Honor, if we could just have audio only for Mr. Robinson to appear, since we will not be present. I would rather not have him in the courtroom without counsel present.
All right. Thank you. I appreciate that. So we will set the court's ruling on those two issues for December 29th at 10 a.m. And note that it will be audio only for Mr. Robinson per defense's request. And to the last issue is, well, before I issue my ruling, I anticipate, and counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are. We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that. And also possibly we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well. I think we have set aside the 30th, and that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom. And we will, I imagine the media will, depending on the court's ruling today, will want to weigh in on that one as well. And that would give them enough time as well. So that would be January 30th.
All right. And before I go to the other parties, the January 30th date, there was some complications. And so we have to find another date.
Okay.
And so I just wanted to let all parties know before we lock in our schedules, what dates do we have available for a 4-hour setting?
It's okay. My problem.
And counsel, I appreciate you giving me that roadmap that helps plan. So it allows the other parties to take in consideration dates and filings as well. So as staff is doing that, they are looking for hearing dates. And one of the complications is, as a judge, I have 1,409 cases as of last Friday. And so trying to find a spot is tricky. And I'm grateful for my...
It's a massive caseload. 1,400 cases? Jesus Christ. Is he counting stuff that's inactive right now? I kind of hope he is, because if he's not, that's almost like irresponsible for him to have a caseload that big. That's a lot of freaking cases. That is a lot of cases. Holy cow. Holy cow. This is in Utah, Buff. Mr. Bunnell. It's in Utah. Yes, his loads are massive, yes. Such a huge load. I know he's not a no-load loser, as Mr. Bunnell might tell. Oh. He's the only judge in Utah, apparently. Indian country, a lot of DUIs. I think this is the felony guy, not the misdemeanor dude. So...
staff who work so hard to manage that calendar. So that is part of the reason for the delay. And we're trying to find a date, because this is an important case, as is all of those cases. They matter to me.
Your Honor, while we're waiting, can I, if I might just make one point that might make things smoother as we go forward with the seal filings? Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify. And I don't know if that is something that they're planning to file, but I was just going to say, sometimes, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify, if Your Honor, I don't know if this is the plan already in this case, or whether that's what they were planning to do, but if they file a redacted version that, just takes out the stuff they care about rather than closing the whole thing, then we don't have to say anything, and probably avoids, fighting over unsealing that document. So I just wanted to say that. I'm happy to confer with counsel if you'd rather us do that, if you don't want to do it by way of a court order. But
no, I appreciate that input. I'll hear from both parties, and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well, and with media counsel. So.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that that January 16th hearing was set with the expectation, the previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night. So we'll do everything we can to respond to those as expeditiously as we can, and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right. I appreciate the heads up. Going to staff, what dates do we have available for in lieu of the 30th? February 3rd, morning or afternoon setting?
Your plan? Mm-hmm. That works for Mr. Robinson, Your Honor.
All right, thank you. And morning or afternoon setting?
Either works for us, Your Honor.
All right.
As well as for the state, we're available on the 3rd.
The afternoon would be better, because it may be that it reduces travel time.
All right. Well, it is always nice when all parties agree. So we have February 3rd at 1 p.m.
There we go, chat. February 3rd, 1 p.m.
Ms. Nestor, is Mr. Robinson planning on appearing?
Yes, Your Honor.
All right. Thank you. All right. That concludes that particular issue about future dates. And I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues. And that will be via WebEx. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right.
He's in jail. He's been in jail. He's a murderer. He's accused of murder. He's not getting bond.
That's in person as well. With, I believe,
he's never getting out.
Defense has indicated Mr. Robinson will be present, and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the attorneys to abide by Rule 3.6 and, in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is one moment as I regain my place as I read. Informing witnesses about the prohibitions in the publicity order is a necessary step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case. And this order will be signed today by myself and made public. Counsel, is there anything further that we need to address today?
Thanks, Your Honor. Yes, just the matter of having Mrs. Erica Kirk designated as the victim representative in this case. She has filed to her counsel a request to be designated as the victim representative, and we'd like the court to formally acknowledge that request and formally designate her as the victim representative. And I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims. But in this case, that case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. We don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Thank you, Mr. Ballard. I'll hear from the parties.
Your Honor, on behalf of Mr. Robinson, we certainly think it's appropriate for Mrs. Kirk to be designated as the victim representative if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Thank you. Thank you to all parties. This court will recognize Ms. Erica Kirk as the designated victim representative in this case. Thank you.
Now, normally that's an issue because if she's going to testify, she's not allowed to be in the trial, but she's going to be allowed to be there in the trial. And ultimately, her testimony, if she does anything, is going to be the spark of life stuff about Charlie. So it's not really critical if she sits there and watches the whole thing. But you would always separate witnesses, but they're like, yeah, fuck it. You're going to let her in. We're not going to fight that one. So, yeah. Here we go. Let's keep going, though.
Counsel, I believe that concludes our matters for the day.
One more,
or maybe not.
Not yet.
I can take the podium, Judge?
Yes, Mr. Gernander.
The purpose, I want to just give the court an update with respect to discovery. We've done that at previous hearings.
I appreciate that.
The state has received approximately 13,900 files from law enforcement in this case. Approximately 300 of those we believe are duplicates. We have since provided to counsel, as of I believe this morning, 7,951 of those files. For the court's information, we had reached close to 100% had been disseminated as of last week, but we received quite a large batch within the last few days. So we are working on that. We still have a full-time paralegal that's dedicated to reviewing that, organizing it, Bates stamping it, and sending it out to counsel. Of course, there are necessary redactions that are being made along the way.
Yeah.
Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right. In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you. What, first of all, how many days does the state anticipate, which helps us in our calendaring efforts?
Judge, given that it's a probable cause standard and all the inferences go in favor of the state is asking for 3 days. We believe that we can present the evidence required to meet that standard, and that would also allow the defense to cross-examine witnesses and argue that standard.
Thank you, Mr. Gernander. Turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with. I don't know when he's talking about, but I don't see how we can set it until all the discovery has been received. And also, we do need to deal with the disqualification motion just in case. So it doesn't seem like a good idea to set it before we have the disqualification hearing. We were only talking about a month from now. I think that should probably be resolved before we set any dates. But I am concerned about setting a date when we still don't have all the discovery materials. We have significant discovery materials that have not been received yet that we know are out there and coming and important. And we have to, have time to review it all and absorb it all. And I am going to be involved in another trial that is not over until the end of March. So that's going to take away my ability to work and process through discovery and communicate with our team. So it seems to me that with the understanding of what Mr. Gernander is trying to accomplish, that maybe we come to the hearing on the 16th with an idea about, we can have some conversations with Mr. McBride and also with the paralegal that's dealing with all the discovery and see realistically when we think we're actually going to have the vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
Mr. Gernander.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident prosecutions. So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures. And it is it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things become available during trial that are discovered to opposing counsel. But it says the prosecutor's disclosures must be made as soon as practicable following the filing of an information, except that a prosecutor must disclose all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. We have to provide it as quickly as possible. We have that duty, and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February and March. And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule a preliminary hearing.
All right.
I'll submit it, Judge.
Thank you.
Your Honor, can I just clarify one thing? I mean, the county attorney has made a decision, very public decision, to announce their intent to seek death the day that there was an arrest, which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're nowhere near getting that material. So that was their decision to release that. Normally that decision is not made until 30 days after a preliminary hearing. They made it in advance, and now they've got an obligation to tell me their aggravation and what they relied on to make this a death penalty case. And we have not received that. So I'm waiting, but I'm just laying that out there for now.
Thank you. I appreciate the arguments from all sides. I do not find there is any prejudice in setting a date for a preliminary hearing. It is not set in stone, and it certainly can be moved. I recognize that the parties have a lot of obligations, but I also recognize the importance of this case moving forward. And if nothing more than this is a goal for the preliminary hearing, if it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is a date that we may have available for a 3-day setting for a preliminary hearing?
Judge, the first week that we would have available is the week of May 18th. We do also have a week of some days in June.
And this is where, guys, they still even had that. They still had the right to challenge a preliminary hearing. Like, there's so much in this case that has to happen still. And just think about that. There's so much that hasn't been done yet.
Accommodate. We do not have any in July. We have some in August.
All right, let's take a look. So counsel, well, what dates in June?
June starting on the 15th.
All right. Counsel, I'll turn to you. Again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for counsel?
May or June?
May 18th is the first date, I believe.
See, guys, we're like the prosecutor's pointing like, look, we'll have the preliminary hearing, but it's not like you're going to win. Also, you don't need all the information because you never do normally. We're having a preliminary hearing May 18th, so this trial is not set for a while now. This just shows you the timeline we're dealing with. We're dealing with like into next spring when the snow's gone and I can have the window open again. A long time away, chat.
So 18th, 19th, and 21st, just to give you the full range.
The state can make those days work, Your Honor.
That's actually not true. Like, you can have trials set that far out. Like, depending on the types of hearings you have, status conferences, reviews, you can have stuff set out that far. Like, I've got stuff that's set for like a year now, especially civil cases. Oh yeah, that can happen too. Very far out. And depending on the federal trials get set out, a lot of the stuff can be structured out. They also might have vacations at that time. Plan that shit out as far as they can. It's a good question. Also, no sure. Good to see you, man. Hope you're doing well. It's been a little while.
Okay, perfect.
Your Honor, we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right, thank you. So May 18th, May 19th, and May 21st. And this will be in person. And do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else? All right. Counsel, thank you again for your hard work today. And I wish you all, Mr. Robinson, a good afternoon. Court is in recess.
Thank you.
All right. So there we go, chat. All right. Family courts don't do business over the holidays. They do, just not as much. Not as much. I've never heard Sean tell a wrenchy it's good to see him. Well, he wasn't a wrench. He's being heavily guarded in jail. Oh, 100%. He's going to be in segregation the whole time. So, but yeah, it'll be interesting to see if we can hear the preliminary hearing. That'll be very interesting to see the information that comes out. Tom's saying is Robinson now appear to person, or will sometimes there be virtuals? Some of these hearings will be virtual, like the one coming up at the end of the month. That's going to be virtual because it's only like 30 minutes. Like, we're going to do that one in and out. There will be some of these, but for the most part, if it's a court hearing, his ass will be in the stand. His ass will be on the bench sitting there. Like, it just all, generally speaking, but it's there will be some of these that way. Let's see here. Candace constantly having evidence revealed to her in dreams. Yes. must speedy trial. He's waiving his right to a speedy trial. He would rather see if he could win. So he needs time. It's still faster than the Russell Greer lawsuit. Yes. Yes. Let's see here. And guys, you're saying this will take a while. Guys, we're now 3 months in. Charlie Kirk got killed like September 10th. We're like 90 days past that point. A murder trial easily is a year to get going. So give it some time. Give it some time. Just pump the brakes a little. Pump the brakes a little on that. Let's see here. Are these public defenders? Yes, they're court appointed. He's got no money to pay for this shit. He's got no money to pay for this. So, Buff Brunel says, the office door is blocked by a pile of paper. What do you think about that, paralegal? Get it? My DSP is not good. I am Uncle Bob is a new member. Thank you, Uncle Bob. Jefferson Post says, I remember back when Judge Ito kicked the press out over a camera looking down at the defense table and some open notes. Very different times to today. Well, the camera was looking at the screens, but it wasn't clear that they could see what was on the screens. But yeah, all that stuff, it's always like, if I go to trial, like, we keep everything closed up. Like, when it's time for, like, the end of, like, if we have to take a break and we have to leave the courtroom because, like, everybody's getting kicked out, like, all the notes, everything comes with it. You don't leave stuff around. You don't leave things open. You don't leave things accessible. Yeah, you don't trust anybody. Don't trust anybody. You know, you get up to go to the bathroom, or I get up to go turn away to do something, flip the notes over. Like, nobody gets to see your notepads. Like, you don't trust. Don't trust. And then Radcott has said, might the defense be wanting to have it happen to the media and streaming kicked out? Yes. I guarantee you they're spoiling for a fight, and they will continue to spoil for a fight. Yes, very true. Very, very, very astute observation. That's what I would do if I were them. My cat's name is Carrot. Says, hey, Sean, I'm at the Christmas parade in my town watching my kids in the marching band. Well, Merry Christmas and hope they're having fun. Hope they're having fun. Honey Badger is saying, in your nursing school, catching up to being your nursing school, you have clinicals on Sunday this semester. So there could be some actual classes on a weekend. Yeah, I get it when you're in like a clinical program, but they made it sound like it's like school, like just general exams or whatever. So, but anyways, good luck on your clinicals. Good luck on those. Good luck. Enjoy yourself. Citric 19 says, I would laugh if he said in the middle of his court that I did it for the art of it, Sean. Yes, that would be funny. That would be funny. Bumps Johnson, good to see you. Saying, I'm not sure if you addressed already. Do you think the jury selection will now have to try to identify Candace Owens listeners? Yes, find the prosecutor. I am going to be worried about conspiracy theorists, all kinds of people. Oh yeah, 100%. That's going to be part of the questionnaire. So you are going to be smoking those people out the best you can. Lucky Live says, death penalty firing squad. Can we move on and stop wasting money? Well, it's all up to Tyler what he wants to do. Thoughts on Sean Ryan stating he used a Crenshaw discovery to probe for his financial information? Seemed like an open admission to a fishing expedition. Well, no, Dan Crenshaw has threatened to sue Sean Ryan. Sean Ryan has said, if you sue me, I'm going to get your discovery, motherfucker. So Dan Crenshaw is the one who's, saying I'm going to fuck with you with discovery if you sue me isn't really the fishing at that point. But I get what you're saying. Jefferson Post says, how can lip readers be right when there's a genre called bad lip reading? Yes. Very true. Very true. Very astute. Very good observation. Shugi Show says, Andrea seems pretty sure we'll lose cameras. Yeah, I at some point I can see it happening. They will fuck this up. They will fuck this up. Is he out on bail? Yeah, he's in jail. SB Seller saying works for Tyler. I fucking hope so. The fuck else do you have going on at the moment? Well, he says Mr. Robinson in the sense of the defense, but also I'm sure that like there's times where when I have clients and it's like My client has to work, Judge. He can't afford. He's on probation. He has a new hire. He's a new hire. He can't afford the points. Can we do a different day? Courts do try to work around that at times. Or I've been in front of judges who are like, okay, like, can we do it in the morning? And the person says, like, well, I got kids. And he's like, okay, well, what time do your kids get on the bus? And what time can you be here? Like, you try to work around all that stuff if you can. But yes, when I've met clients and they're at the jail before, they're like, hey man, what time is it? And I'm like, it's like, it's like 3:45. You pull out your phone, you're like, it's like 4:00. And I'm like, got a hair appointment or something? They always chuckle. But time moves slowly. You want to know the time. It's something to know. Johan says, when he gets a death penalty, we need to broadcast it all. That would be fun. Yes. Jefferson says, my brother lives in Providence. Told me people were sheltering at the coffee shop his girlfriend runs a few blocks from the incident. It's a small city. Yeah, I mean, it's okay. It's not Boston, but it's still a bigger city. Bigger than the cities I live in. Bob Tube for $2 Australian doodles says, which is going to go longer? The steel toe TRO, the HROs, or the Charlie Kirk murder trial? I don't know, man. I don't know. That's a tough one. Tough one right there. So let's see here. How many of the 13,000 files are unhinged rants about Charlie Kirk? They might be. Who knows? Just the amount of discovery is going to be, and this is going to be huge. Remember, every police officer who did something types a report. That report is reviewed. Maybe there's a supplement. Like, there's so much work, so much to review. Phil says, massive discovery. Yes. Quality content. Yes. DSP tries it. Neutral loaf. That'd be funny. Yeah, they're going to be going until Juneteenth. Yeah. I like defense counsel. She's afraid to fist fight. That's true. Let's see here. What do we got to do here? Why do we get glucose ads when I watch your streams? I don't know, Mr. Squiggles. I don't know. Maybe YouTube knows something I don't. But anyways, for 38 months, thank you for being here, man. Quippy's Revenge says, have you ever taken a murder case for a poor? Yeah, I've been appointed to a guy I've been appointed to people who have been had murder, like that happened last year. Yeah, it was very interesting. Learned a lot. But most people who have murder cases are generally going to get court-appointed counsel. Most people who commit murder or accused of committing murder are not going to be able to afford their own attorney. You're talking about like, like if like you walked into my office and like, hey, Sean, can I hire you? What happened? I got accused of murder. It's like, okay, you're going to need like 50 grand on the table right now, and that's going to disappear instantly. We're getting experts and all the things we need. So, yeah, I mean, like, it's an insane amount of money you would need for a murder trial. Think about it. Karen Reed, how much money did she need? A lot. You get Harbor Freight ads. Well, there you go. The prosecution didn't seem all that combative. They don't need to be at this point. This isn't really the battles for them to fight. The only thing they're worried about is getting in trouble violating the gag order. So remember, you only fight where you need to fight. So they're giving up on that for right now. Let's see here. Yeah, people like Bronco wouldn't be cheap. True, yeah. Murdaugh's trial cost $600,000. I could easily see that. How much does it cost to keep someone in jail? I mean, that county factors in as part of their budget every year. Even if he gets a death penalty, it'll be 20 years before the deed. Yeah. Zachariah Anderson's trial was $300K. Yeah. Yep. No, that's true. Hold on here. Shadows, I'm going to need your exact rate for a murder trial for reasons. Well, I don't know what to tell you there. I don't know what to tell you. Kia Path says, imagine paying for YouTube. Well, I pay for YouTube so you guys don't get ads. Because having ads in the middle of our shit would be really annoying and gay. Let's see here. It was worth it for Karen, yeah, but I mean, that's... Just Josh, good to see you saying, have you been following the Brian Walsh trial at all? No, but from what I've been watching Peter Tragos, actually, like listening to him when I drive around. It sounds like Brian Walsh kind of fucked. Sounds like there's a lot of evidence that kind of fucks him. So, let's see. I dodged that question. Well, I am light on my feet when it comes to questions. Let's see here. What's your hour rate? Does it change depending on the case and whatnot? Well, no, my hourly rate stays the same. That's how I factor in things. Like when it comes to criminal stuff, though, most people don't have the ability to pay you like as an hourly rate, like a monthly bill. You give them a quote for the whole case, and that's part of the thing. Like, you know, that's the common way around here. Like that's some places you might not be, but like a DUI, and like you get a DUI and you get into an accident, and you're just like, I need to make sure I don't go to jail forever. $1,500. I want to go to trial on it, and I want to suppress everything. It's going to be like $5,000. Trying to do it as an hourly rate thing doesn't really work that way. What you do is you take your hourly rate and you're like, okay, I'm going to spend X amount of time doing this. And that's how you come up with that. Dolly says, do you still record hours? Yeah. They're like, you still keep track of stuff. You still keep track of things. Yeah. You still keep track of stuff just to help kind of like break things down. Then there's going to be times like for civil cases. Yeah, you might like civil cases. You probably will do things on an hourly scale. So you really do keep track of time there. It all depends on how things are set up. But for criminal cases, you generally don't do the, you're not doing the typical lawyer billable hour thing. Not the same way. Like I said, maybe it's different in different places in the country, but like here in this area, it's not like, no, you get as much as you can up front and you work with it because that's pretty much all you're going to get with people. What if you have 18 DUIs? Well, you're fucked. And I'm about to commit a crime. Can I go ahead and pay you? Yeah, sure. You can give me money ahead of time. Yeah, you could do that. You could do that. You could do that. So you do so you can adjust the hours next time. Well, what do you mean? I'm confused, Adam. Let me see if you asked something earlier. I don't see what you're talking about. Let's see here. Do you charge in 10th hour increments? Well, you keep track of that. That's the standard. Keeping track is of 6-minute increments. There are like the old ways of like 15-minute increments and all that shit. That's just not a good idea anymore nowadays. Just you can all be electronically done. So why not just do it that way? It makes more sense. Dolly says, I know a guy in Warren County who needs a civil lawyer for his second trial. He's currently pro se because he fired his last lawyer. Well, you probably don't want that guy because he's firing his lawyers. That's not going to be fun. Stabby's saying if he had attorneys on retainer insurance, those places won't defend you when you straight up murder somebody like that. And there's no self-defense angle. Let's see here. Oh, you're saying if the DUI takes too long, sure, up the bill. Well, it sometimes doesn't always work that way. Like let's say something happens and I end up like breaking even. Like I spent all the money and like I didn't I did it for X amount of hours and it ended up working the exact amount of hours. That happens sometimes. Sometimes you can go back, but depending on how your retainer agreement's written, like if I charge you like $5,000 to go through suppression and trial and a little bit more, like I might not be able to get it. That's part of the, pricing game. I make the estimate and gauge on like how much money it's going to take. So let's see here. No, I cannot be paid in magic spells. Oh, yes, you keep track of the hours because when you quote the next time, you'll know how long it took. Yeah, well, you generally know how much it's going to take. Like for a DUI, you know, there's going to be a police report, probably 2, 3, 4 pages. There's probably a little bit of body cam to watch. There's a little bit of dash cam to watch. There's going to be some test results to read. Like you don't have a ton, like there's not a ton generally you have to worry about. But yeah, depending on the case, the more and more things, yeah, you kind of have a rough idea. You generally have a rough idea. So you don't have different rates per hour for research versus court. Not typically. I mean, like you're doing the work, you're doing the work. I mean, some attorneys might. My rate is my rate. Like it's a lot easier that way. Like if you do appointed work, like if you take an appointed case, yeah, you have to differentiate between in court and out of court. Although some counties, it's the same rate across the board. So, but yeah, no, I don't charge a difference there. Likes, do you accept doll hairs? No. How about World War II models? No. Let's see here. Am I going to cover the Boffer case? I don't know what that is. So I'm not sure. Robin Hood says, can I pay you in RAM? Both for these nuts. Yeah. Quippy, you're saying what's a normal profit margin? I would have to sit down and do the breakdown of it. But if you're 50%, I think actually would be very unethical. If I'm billing you that, so let's say you come to me and I know I could do it for, it's going to cost me like $1,000 total in time and expenses, but I charge you like $2,000. That you're kind of getting to the point of like, is that actually earned money at that point? I don't know if I wouldn't feel comfortable charging like that. That's a lot of money to get off the top in that regard. So that would be a little bit there. I hope that answers your question. Yeah. Oh, that's a shame. Good to see you. Congratulations again, and I hope you're doing really well out there. It's good to see you. It's been a little while. Can you accept pirate booty due to the probability of ill-gotten provenance? The provenance of things? If you gave me shipwrecked treasure, I could probably accept it. If you came in with like conflict diamonds, no. The 33% thing you're talking about, Karen, that's the contingency fee arrangement. And that's part of it. Like if I can't make more than that as a contingency thing, I think I'd be probably in trouble trying to get that out of a client for a flat fee case. Remember, fees have to be reasonable. Like if you end up charging somebody $100,000, but I only do $1,000 worth of work, am I entitled to keep all that 99 grand? No. So remember, fees have to be reasonable and you have to do the work to earn the fee. So, obviously 99,000 wouldn't work. Would I probably be allowed to keep 1,000? Probably. But even then, I don't think I would be comfortable doing that. You shear sheep, you don't slaughter them. And also that guy in the future might say that motherfucker kept all that money. That's bad PR. So let's see here. Child mine cobalt and lithium? No, I can't do much with that. Oh, Quippy, you're saying how much of the cost is generally your labor? I mean, most of the cost is my labor. Like the cost to run the printer behind me or search engine or whatever. That's like those are very minuscule costs. All that work is me researching, me preparing, me arguing. It's all me doing the thing. So almost all of it's labor when it comes to an attorney. I think that'd probably be a fair way to look at it. So Karen says, I hear paralegals do most of the work. Depends where you're at. I don't have a paralegal, so I do most of my work. But yes, paralegals do a lot of work. Unless you're Russell Greer, then you don't want them doing any of your work. So let's see here. Benjamin says for $5. There's an entire board game about the OJ trial called Squeeze the Juice that was about getting more money from Simpson. The trials can be expensive, yo. Yes, they can. Yes, they can. Holy shit, they can. That'd be a fun board game to play. Oh, let's see. I'm my own paralegal. I'm my own secretary. I'm my own, whatever. Yeah, I'm the equity chair. I am the managing partner. I am the head of the DEI department and DEI initiatives. I'm executive vice president for HR. I'm all of it. Yeah, that would be a fun game. Oh, you're just get. Oh, I'm just. Oh, okay. Well, I wasn't sure. I thought you're just asking. I thought I'd answer. So, Train Clyde answer the phones. Yeah, I am the janitor. Yep, I empty out the garbage cans. All that fun stuff. Can I get freelance paralegals? Yeah, you can hire people for temporary things out there. Yeah, sure. Sure. Totally. For my paralegal fund, thank you. Thank you, EDW Raptor. So you're saying Clyde has no say in the business, correct? You're saying it's a reskin of Monopoly, but instead of money cash, you just have checks from OJ. Nice. Do I sexually harass myself? Yes. And I'm the intern who gets coffee. Yes. Who do I blame when I screw up? Myself. So, all right, chat. Well, this is it for now. We are going to hang out for a little while. We're going to hang out for a little while. Flash reached out. I think he may have me on later tonight, like 10:30, 11, or every time he starts. There's some stuff with Smash AT going down and some other stuff out there. But in the meantime, we'll probably do a little bit of painting and hang out. We're going to work on some of that stuff that Stabby printed out. So we'll be going over there in a second here. Let me see if I could set this up. Let's see here. Okay. Also, Stabby, I sent you a comment over on Discord. I was asking a question about the guy you printed out, because I didn't know anything about him. So if you we'll just get to that here in a second, guys. So yeah, we're all set. Time to have some paint, yes. Very true. Erica says, who's Flash? Yellow Flash. So, yes, it's good to see Nate doing stuff again. Nate is doing awesome. I am so thrilled and happy to see him thriving, and I have nothing but well wishes for him and his family. Like I said, I want them to be able to look back on a year and go, "Ha, wow, man, that was a dicey couple of months," but we're back on laughing at it on the other side. So I am totally looking at that in that way. So yeah, Nate's doing really good. Nate's doing really awesome, and just guys keep him and his family in your thoughts and prayers. I know they would appreciate it. So, All right. I pray Naked and Lex for the holidays. Yeah, he's hanging in there. He's hanging in there, guys. So, let's see here. Haschick says, I'm accounting, HR, billing, ordering, research, logistics. Yeah. Yep. Yes, very true. It's very much the same way for me. So, all right, chat. Well, we're going to leave it here. Thank you guys all for being here. 300 people hanging out. We will keep track of Tyler as it goes forward, but yeah. See you guys over on the model channel, and just remember till next time, just because you did it does not mean you're guilty. Although, I mean, let's be real, Tyler Robinson probably going to get convicted. I mean, I don't see how it's not him. But it is what it is there. It is what it is. So let me... Well, that didn't work over here. But anyways, chat, I will see you guys all tomorrow. Good night, everybody, and take care. Meme says, just got here. Can we start again? No, sorry. Suffer, Meme. Suffer, Meme. Anyways, take care. Good night, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go, here on Sean Martin's Potential